Congressional Democrats are facing increasing pressure to move forward with voting rights legislation following the Supreme Court decision to uphold voting restrictions in Arizona last week. At issue were two rules in the state. One bans the collection of absentee ballots by anyone other than a relative or a caregiver, and the other requires election officials to throw out ballots cast at the wrong precinct. But the High Court found that neither of those laws violate a key provision of the Voting Rights Act. For more on this, I want to bring in Jessica Levinson. She's a CBS News legal contributor and professor at Loyola Law School. Jessica, thank you so much for being with us. I always learn a lot from you on these challenges, so I'm glad you're here to break it down for us. So this suit was not a challenge to the Constitution, but the landmark 1965 Voting Rights Act. What impact does it stand to have moving forward?
And I think it's so important that you mention that, because this is not a constitutional case, which means that if Congress wants to change the standards, it can, with maybe one caveat that the Supreme Court said, Congress, if you're going to change this, don't go too far. But you asked me about the impact of this. It's hard to overstate how difficult it will now be for people who want to challenge restrictive voting laws under what's left of the Voting Rights Act. As you said, these suits came up under Section 2, which essentially requires that individual people prove that either there's been a disparate impact, meaning the effect of a voting law is to harm people of color, or a discriminatory intent, meaning that the lawmakers actually wanted to harm minorities. This was an effects-based test, and if you read the court's opinion, it is so difficult to imagine that there aren't any cases other than the rarest cases where you have an incredibly restrictive law that anybody can be successful in trying to overturn a state law under what's currently left of the Voting Rights Act.
Right, and that seems to be the argument from lawmakers on Capitol Hill pushing for legislation on this, and that seems like still such an uphill climb given the breakdown in the Senate. But if you are in some of these other state legislatures looking at this decision, what kind of impact do you think it can have at the state level in terms of enacting further restrictive laws?
Yeah, I mean, that is the question, right? I think it's essentially open season for states who want to enact more restrictive laws. And we know that there have been about 24 states just recently who have enacted what I would view as some version of more restrictive laws either. And, you know, what specifically are we talking about for voters? Reducing the time that you can vote early, making it harder to get and return absentee ballots, having to have a specific type of voter ID. And I think what this decision really means, because it's based on a national piece of legislation, is that we're going to have this really pronounced patchwork of laws, where in some states, like I'm talking to you from California, we try and make it very easy. If you're eligible, here are all the ways that you can vote. And then people who live in a neighboring state, they're going to have a very, very different experience. We don't have that floor of protection anymore.
And what kind of roadmap does this provide for Congress? You mentioned that this will require some congressional action, of course. You know, they started out with a big, broad package. They're also trying to bring up, again, the John Lewis Voting Rights Act, which would restore provisions struck down in the Voting Rights Act. But if you are kind of looking at where Congress can go from here, where are some more perhaps targeted approaches?
Yeah, I read the Supreme Court's decision here by Justice Alito as saying, Congress, tread lightly, because we know that in 2013, the Supreme Court struck down part of the Voting Rights Act, essentially saying, Congress, you're reaching into what states can do. The federal government is reaching into what states can do, and you're doing that too much. We don't think there's a good enough reason for that kind of invasion of state sovereignty. So what I think is that this is the Supreme Court that's kind of telegraphing to Congress, don't try and overreach. And of course, you know, the big For the People Act is a huge omnibus bill. Politically, I don't think it has a chance. And legally, I think it could have problems with this court. So you want Congress to have a targeted law that really just focuses on this idea of effects for minority voters. I think that has the best chance of surviving and providing a really clear standard, something that states have to adhere to without it looking like it's reaching in too much, because we know under the Constitution it says states, you determine the time, place, and manner of elections. Federal government can't invade that too much.
And Jessica, now that the court has wrapped up for the summer, there is growing pressure on Justice Stephen Breyer to retire. What do we know about his plans now that the court is in recess?
I think we know his plans are to not retire. Now, I'm happy to come back and have not just an egg, but an omelet on my face, because I was completely wrong on this one. But he has hired a full complement of 4 law clerks, which is always an indication that he expects to work full steam next term. He's also made a couple of speeches where he's basically said, I don't like all this political pressure. We're supposed to, we have lifetime appointment because we're supposed to be separate from that. I think progressive would say, please learn the lessons of Justice Ruth Bader Ginsburg. He would say, I have this job as an Article III judge. I'm here for life. I feel good. And he doesn't seem to be indicating he has any desire to time this according to an upcoming election.
That's right. Progressives certainly hoping otherwise, but we'll see how that goes. Jessica, thank you so much, as always, for being here.
Thank you.